Hello, I'm Peter Grove, specialising in intellectual property law, and I'm also a lecturer and author. This is the first of what will be a series of short lectures on trademark law to give you a brief introduction to the subject. If you want more detail, there are other products that you might be able to get some help from, and I will give you links to them on this YouTube channel. If you're studying intellectual property law, you probably know about some other areas of the subject, and you'll have spotted that trademarks are rather different from copyright or designs or patents. Although they're intellectual property, whatever that means, there's nothing necessarily intellectual about them, and if there is, that's probably protected by copyright or design law. If the title of your course was Intangible Property, then trademarks would fit much better. And if we talked about industrial property, as the Paris Convention did back in 1883, again trademarks would fit much better. What a trademark is a special type of sign. Signs are devices for communicating information. They commonly come in some sort of graphic form, in writing or pictures, but that's no longer necessarily the case with trademarks. And signs communicate all kinds of information. They give you instructions about what to do when you're driving. They show you where the fire exit is. They tell you you can't smoke. In the case of a trademark, they tell you about the origin or source of goods or services. And because they make that connection between the goods and the person who makes them or the person who supplies them, or services, the person who performs those services, they are very strongly connected to the goodwill of the business that uses them. I want to talk about a few preliminary matters first. If they seem like personal bugbears, then I apologise, but I think they're important points. They're important if you're writing an exam, and they're also important if you're in practice and your clients expect you to get the words right. Lawyers, of course, work with language. So, is trademark two separate words, or is it one word, or is it even hyphenated? Well, if you look at your copy of the Trademarks Act, there's no doubt about it. It's two separate words as far as the UK is concerned. In the United States, the words have been run together, a bit like copyright was run together many, many years ago. And in common usage, you'll often find that the words are run together as well. But I think lawyers should take their steer from what the statute says. As for the hyphenated version, well, we can forget about that now, because it used to be the way they did it in Canada, but they changed their law not long ago. I'll be talking briefly in this lecture about passing off, and there's another lecture on the YouTube channel about that. So is that hyphenated or not? Well, it depends on what you're using the words to do. There are grammatical rules about it. So it would be the law of passing off with no hyphen, but if you're using the expression in a sort of adjectival way, it would be hyphenated. So a passing off case has got a hyphen in it. When do we talk about trademarks and when do we talk about signs? Well, as I just told you, a trademark is a type of sign, but of course not all signs are trademarks. And because the Trademarks Act uses the expression trademark to mean a trademark which is registrable under the Act, it's often appropriate to use the word sign in a neutral sort of way so that you're not making any presumptions about registrability. So a trademark owner might sue somebody who is using a sign which is identical to or similar to their registered trademark. What about brands? What's the difference between a brand and a trademark? Well, I think the answer to that is that a brand is something bigger than just the trademark. The trademark's a very important component of it. It's the recognisable bit of it, but a brand has got a lot more baggage attached to it. It has values that are independent of the trademark, but which consumers recognise and are attracted to, or possibly repelled by. And while I'm talking about brands, you might find this infographic interesting. I certainly did when I first saw it. I think by including the Oxfam logo in the bottom right hand corner, I'm ensuring that I'm giving appropriate acknowledgement to this. You won't be able to see all the detail on it, but it just goes to show something about the power of brands and something about the value of brands. And it really makes you stop and think when you realise that all those brands that are too small to see in great detail belong to such a small number of multinational food companies. And we are only talking about food here. What about these abbreviations, the encircled R and TM? What do they mean? The encircled R is taken as an indication that the trademark is registered, whereas the TM bit is taken as an indication that the sign is a trademark and not some other sort of sign. So it's a kind of claim to the status of the sign to which it's attached, which isn't backed up by registration as a trademark, because, as we'll see, there is common law protection for trademarks to a certain extent. It's a bit more complicated in the United States, and that's where these things particularly come from. And to cut a long story short, in the United States, you bring a trademark into existence by using it so that customers come to recognise it. It acquires protection at common law, and you can register it to make that protection a bit stronger and more effective. Whereas in the UK, where that's the way things used to work before 1994, now it's the act of registration which creates the trademark within the wording of the Trademarks Act. So the use of the TM is a little bit confusing there, because it goes against the basic principle of the Trademarks Act, that the definition of a trademark is something that can be registered. Trademarks commonly should be capitalised, at least have a capital initial. They are not nouns, so what you clean your carpet with is not a hoover, nor are they verbs, so the action of cleaning the carpet is not hoovering. They are adjectives, so you clean your carpet with a Hoover vacuum cleaner, and that's Hoover with a capital H, which is appropriate because it was once upon a time somebody's surname, and then it became a company name, so a proper noun, it needs a capital. But when it's used as a trademark, it's working as an adjective. And here's an example of, well, an organisation which I admire greatly and whose activities I take part in almost every week, but I don't think they use their trademark properly. I think their insistence on having a lowercase p at the beginning of parkrun is dangerous from the point of view of trademark protection. And they've got registered trademarks, but using the lowercase initial letter suggests that this is just an ordinary word which other people are entitled to use. How do we justify giving exclusive rights to trademark owners? After all, if you allow somebody to register a word as a trademark, then you're giving them exclusive rights over a little bit of the language, which isn't something you should do lightly. Well, we can't justify trademarks as we can copyright and patents by saying that the owner has created it and therefore it's his or hers. And we can't say that by allowing people exclusive rights we encourage them to create more, because that's not what trademarks are all about. But there is a utilitarian justification for protecting signs which are used as trademarks, and that's to do with consumer benefit. If you're feeling hungry and you need a bar of chocolate or something to stave off the pangs of hunger until you can have a proper meal, you go into a shop and look at what's available and you recognise, say, a Mars bar immediately. Economists would say that your search costs have been minimised. The trademark instantly communicates a lot of information to you, which is probably largely based on the fact that you had a Mars bar before and you enjoyed it. So the trademark doesn't just minimise your search costs, it also acts as a sort of guarantee of quality when you find the product you want. And of course it encourages you to buy it, so that's what makes trademarks valuable business assets. You're not actually bothered about whether the Mars trademark belongs to Mars Inc. or Nestle or Kraft or Unilever or any of the other companies we saw on that infographic a little while ago, although it is pretty obvious which of those it does belong to. But what this means is that businesses can sell brands, they have a value, they're transferable assets, and sometimes they're the most valuable assets a business has got. Sometimes It doesn't have any other assets at all. It only has liabilities. A lot of big corporate transactions take place because people want to acquire the trademarks, and they take all the baggage that comes with them, just as part of the deal. In fact, there's been quite a lot of thought about what trademarks do from a legal perspective in recent years, and the Court of Justice has developed ideas about this. It's moved on from just the origin function of a trademark. It's no longer simply an indication of the source of goods or services, but they recognise also the guarantee function that I just mentioned. And they've also gone on to say, this is the judges in the European Court of Justice, they've gone on to say that trademarks have got an advertising function and an investment function, recognising the fact that they're valuable business assets. So in the modern world, trademarks perform a range of functions, and to make sure they do their job properly, they get legal protection. What I'm talking about in this lecture is the protection that you get from registration, and registering a trademark confers exclusive rights. Those rights, however, are limited to the goods and services that you specify in your application, and therefore which come through in the registration. The idea is that these are the goods and services on which the trademark is used, or at least which you're planning to use it on in the fairly near future. But trademark owners usually have shareholders looking over their shoulders, asking them whether they're using the business's assets to the greatest possible effect, and companies which own trademarks, particularly bigger companies, therefore try to do whatever they can to turn the limited exclusive rights that trademark law is supposed to give you into monopoly rights, which is not what the law is trying to do. And they do this actually in two ways. They register for a very wide range of goods and services, and they break down their trademarks into component parts and register each of those components as trademarks in their own right. This is not very helpful because it makes it extremely difficult sometimes for new entrants to find a trademark that they can use without infringing somebody else's rights. And it's a very regrettable tendency in modern trademark law and a significant problem for clients. Protecting these signs is not a new idea, it's not even a modern idea. There's been protection for what you would recognise as trademarks since at least the 16th century at common law and in equity. The common law and equitable actions have now given us what we recognise as the law of passing off, and passing off actions remain as a very important fallback, but registration of a trademark is now almost essential. The act of registration of what brings the trademark into existence, and the danger is if you don't register it, then somebody else might do, or register quite innocently one that's so similar to yours that yours becomes useless. Registration of trademarks is governed by the Trademarks Act 1994. It's part of a wider European Union-wide scheme, which has got two components to it. First of all, the creation of a European Union trademark system, which I'll talk about in a moment, and secondly, the harmonisation of national and regional trademark laws in the European Union, so that the substantive law in all the trademark systems operating among the 28 member states is the same. There will be changes to this when the UK leaves the European Union, if the UK ever leaves, but it's highly unlikely that trademark law is going to diverge very much from what's going on in the European Union. And actually the latest amendments to the Trademarks Act were made as recently as the 14th of January 2019, mere weeks before we were due to leave the European Union, but the government still took the view that the latest version of the EU directive needed to be implemented in the UK. We were legally obliged to do it, but whether anybody would have taken the point during the few weeks that remained, I think is doubtful. But as far as trademark law is concerned, membership, full, complete membership of the European Union system is generally seen as a good thing, and Brexit isn't going to make a huge difference to the way our law works. As things stand at the moment, well, and as they'll stand in the future, if you want protection in the UK, though, you can apply for a UK trademark or get an EU trademark, which will also give you protection in the UK. by virtue of its membership of the European Union. After we leave, some mechanism will operate to carve out the UK rights from every European Union trademark, and there'll be a whole raft of new corresponding trademarks in the UK. For the time being, whether you're going to satisfy yourself with the UK trademark or get an EU trademark really depends on the scope of the protection you want and the amount you're prepared to pay for it. The basis of the EU trademark system is a unitary trademark which is valid throughout all member states, governed by a council regulation. The latest version of which came into operation in 2017. Having a single unitary trademark simplifies administration, saves on renewal fees. There are many advantages, but there are also disadvantages to putting all your eggs in one basket, which I think is beyond the scope of this brief lecture. National trademark systems remain, and also the regional system which the Benelux countries set up in 1958, I think, and the directive harmonises them. If you're wondering whether to go for an EU trademark or a national one, then bear in mind that the cost of an EU trademark is going to equate to approximately 3 national trademarks. So if you're active in more than 3 countries want trademark protection there, an EU trademark might turn out to be better value, but for various reasons there's more to it than that. Many businesses of course need protection outside the European Union, so they're interested in how they can file applications in other countries. And apart from going to each individual trademark office and paying their fees and having local lawyers represent them, they can use the system which leads to the grant of an international trademark, which isn't really international, it's the application process which is international. The trademark you get at the end of it is national, just like you would get if you applied direct, but the process is greatly simplified by 2 international agreements, the Madrid Agreement and the Madrid Protocol. The protocol is now the more important of the 2. I think the UK and the European Union and many other countries around the world are parties to it. The way it works is that it enables a trademark owner or an applicant for a trademark registration to use the application or registration in their home country. So it's got to be the country where they're based, where they make the initial application. On the basis of that home country application or registration, they can make a single international filing designating other countries and the European Union if they wish, if they haven't already got that. It saves a lot of legal costs because you very rarely need local lawyers, except I might mention in the United States, where there are so many formalities to go through, you almost always end up instructing somebody to help you there. So the trademark system is very helpful and useful to businesses. It's got problems though. In the UK and the European Union and many other countries around the world, trademark registers rely on the owners of earlier trademarks to oppose later applications that conflict with their trademark. Before 1994 in the UK, the registry would refuse an application if somebody had already got there first. But one effect of the European Union trademark project has been to get the UK to change its approach, and we therefore have what's referred to as an opposition-based system, which loads a lot of costs onto trademark owners. They have to keep an eye on what's coming through the registry. They'll be notified about some conflicting applications, but there might be others that they want to know about that they can't find out about unless they maintain a watch, so they probably pay an agent a fee to alert them to what's being applied for. Then they've got to pay the opposition fee, and they've got to pay lawyers to draw up the papers and, in some cases, attend hearings and things. I already mentioned how trademark owners try to turn their trademarks into monopolies by registering for wide ranges of goods and services, and also breaking down their trademark into component parts. Registering for lots and lots of goods and services leads to depletion and foreclosure. In the EU system, this used to be made worse by the fact that you got 3 classes of goods and services, for the price of one. All the goods and services in the world are broken down into 45 different classes, and fees are payable accordingly. But in the EU system it was common practice to go for 3 classes because you were getting them without paying any extra fees. Well, now you only get 1 class and you've got to pay extra fees for any after that. There was also the problem about whether class headings mean all goods. I'm not going to try and explain that to you at the moment. That's going to come later. The registrations of small components of a corporate identity also lead to a crowded trademarks register. Because the companies that own the trademarks have got shareholders watching their every move and making sure their assets don't get devalued, enforcement can sometimes be vigorous, not only in infringement proceedings but also in opposition to other people's applications. So there are a lot of what look like fairly spurious opposition proceedings and sometimes fairly spurious infringement proceedings too. But a trademark owner has got to be fairly dutiful in taking action to protect their rights, otherwise they risk, if not losing them, at least seeing them devalued because there are too many people using similar trademarks in the marketplace. I think it's fair to say that in order to be an effective trademark owner you've really got to suspend your sense of humour. And finally, it's also worth mentioning as a potential problem perhaps the fact that the Court of Justice has been dreaming up new functions for trademarks in the case law in recent years. It could be that somebody who doesn't think they're infringing finds that the judges in the Court of Justice take a different view because they've thought up something else that trademarks do, making the activity that's complained about unlawful. The psychology of the way that trademarks work gives rise to problems as well. A lot of consumer buying behaviour is subconscious, and this has given rise to a large problem with look-alike brands, particularly with supermarkets, hoping to gain a competitive advantage by creating a connection to famous brands in consumers' minds. So the Sainsbury's instant coffee will look pretty much like the Nescafe instant coffee on the shelf, and consumers might not be attentive enough to discern the difference. People tend to generalise, and most often they will associate different brands on the basis of colour. But in spite of the efforts of the brand owners back in 1994, there's no specific protection from lookalikes in the trademarks legislation. Which leads neatly into the next slide, and I can talk about what the legislation is. The Trademarks Act 1994, which has been amended a few times in its lifetime, most recently on the 14th of January 2019, is the key domestic legislation. It's based on Directive 2015-2436, which harmonises national trademark laws in the European Union, and it also reflects many of the provisions of the trademarks, the EU trademarks regulation, which is codified as the under that name in Regulation 2017/1001. The substantive rules in all of those should be identical, except where options are provided in the harmonising directive. So let's look now at what can be registered. Conveniently, this is in Section 1 of the Trademarks Act 1994, which tells us that any sign which meets the requirements of the legislation can be registered. Sign includes words, including personal names, designs, letters, numerals, and the shape of goods or their packaging. That's the non-exhaustive list set out in Section 1, but experience shows that other things can be registered as trademarks too: tunes, smells, colours, gestures, and more. In principle, anything which can constitute a sign and meets the requirements of the Act can be registered. They've caused problems in the past, though, because a lot of those things were difficult to put on the application form. Even when the application form went online, it still basically required a graphical representation of the trademark so that it could be put on the register. And indeed, until the 14th of January this year, the trademarks legislation required that the trademark be capable of graphical representation. Now it merely has to be capable of being represented on the register in a manner which enables the registrar and the public to determine the clear and precise subject matter of the protection given to the trademark proprietor. A bit of a mouthful. It was much easier when it was capable of graphical representation, but we've moved on from that, and that's going to make life much easier for some of the exotic or non-traditional trademarks: sounds, smells, colours, movements. And then a trademark has got to be capable of distinguishing the goods and services of one undertaking from those of others. That really defines the origin function, the source function of trademarks, and it separates them, sets them aside from other types of signs. That's the type of information that a trademark is supposed to be communicating. So a trademark which isn't distinctive is going to be in trouble. We call these things trademarks, but do they have to be used in the course of a trade? There's no requirement that a trademark be in use at all, actually. Merely having an intention to use it is enough to file an application. If it's not used for 5 years, that becomes another issue, but we're not going to touch on that now. So, if there's no requirement that you use a trademark at all, there's no requirement that a trademark be used or intended to be used in the course of trade. You might say that because we're talking here about trademarks, that's inherent in the concept. It must be something that's used in trade. Well, if that requirement is inherent in it, it's been very much weakened. And I think partly weakened by the fact that many bodies, which previously you wouldn't have thought of as being in trade in any sense, do engage in some trading. The Intellectual Property Office itself is engaged in a certain amount of trade, and it's got registered trademarks. But my all-time favourite is this Royal Marines Commando trademark, and there are so many things which are really weird about this. It's not just a national trademark, it's a European Union trademark. I wonder if our NATO allies know what the commandos are doing on their territory. I haven't shown you the list of goods and services, but it's huge. And I'll just tell you that it includes bird baths. I must say I find it extraordinary that taxpayers' money is being used to register trademarks like that. Once a trademark's registered, it can last forever. You've got to pay renewal fees every 10 years, and you've got to use it unless you've got a good reason for not doing so. But subject to those requirements, it can carry on forever. You probably know this painting, The Bar at the Folies Bergère by Manet, but can you spot the trademark? Here we are, UK registered trademark number 1. It's been on the register since 1876, and it's still there today. It's going to be renewed on the 1st of January 2022. Let's go back to consider the definition of a trademark, because we're now getting to the part of the Act which tells you what you can't register as a trademark. And the first category of things you can't register as trademarks are things which are not trademarks at all. If your sign cannot constitute a trademark, it can't be registered, and that might be because it can't be represented adequately. In the old days, not capable of graphical representation. That's less of a problem now that the law has changed, but it hasn't gone away entirely. If the trademark's not capable of distinguishing the goods and services of one undertaking from those of others, then again, it's not going to be registrable. It's not a trademark. The law is concerned with a capacity to distinguish. A trademark might be able to distinguish one undertaking's goods and services from those of others, but it's not doing so yet because it's not recognised by consumers sufficiently. That's a different issue. That would be a trademark which is capable of distinguishing. It's just not actually doing it. What we're concerned with under this heading is a trademark which is so utterly non-distinctive that it's never going to work as a trademark. It's not capable of distinguishing at all. So if you're a baker selling bread, using the word bread to identify your business is going to tell consumers about what they might be able to buy there, but it's not going to be able to help them distinguish between your products and those of any other bakers. Well, it didn't matter so much for this baker because this was in Schiphol Airport in Amsterdam, and within that context there's not much need to distinguish yourself from other traders, but certainly the word bread would never function as a trademark for bread. Well, that can happen with a trademark is that it's not a trademark. It's incapable of distinguishing one party's goods and services from those of others, and if things are that bad, they can never be put right. More often though, you'll find a trademark isn't registrable because it's devoid of distinctive character. Not incapable of distinguishing, just not distinctive at present. And of course many personal names turn into trademarks as they're used in trade. Many place names also become trademarks. They're not suitable from the outset, but they can be registrable once they acquire what's called a secondary meaning, or they have acquired distinctiveness. And it's not just personal and place names that are a problem. A lot of trademarks are lacking in distinctive quality because the marketing people who devise them want to tell the public something about what the goods are, why they might want to buy them. So the next level at which problems might arise for a trademark is that they are descriptive. Look at the wording of section 3.1c. It talks about trademarks which consist exclusively of signs or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time of production of goods or rendering of services, or other characteristics of goods or services. Having the word exclusively in there opens the door to the possibility of adding something distinctive to make it a more workable trademark. So for example, taking words which are on the face of it descriptive but putting them into a logo so that the end result is a distinctive composite. The reason the nappies, or as the reason, appear on this slide is because this was one of the earliest trademarks considered by the Court of Justice. When Procter & Gamble tried to register Baby Dry, and the Court of Justice actually set the bar pretty low and said that's okay. These are not words that you normally see together, and there's no descriptiveness problem. Baby Dry functions as a trademark, as an indication of origin. Windows is another example of a trademark which was pretty descriptive when it first came into operation, and you can understand why the marketing people at Microsoft wanted to tell the world something about the way in which their new graphical user interface worked. However, it took quite a long time to acquire enough distinctiveness for that very descriptive trademark in order to satisfy the registry that it wasn't too descriptive to be registered. And the dates on this extract from the register don't really tell the full story, and I'm sure there's a great deal more that you could find out about it. But the application wasn't even published until nearly 4 years after it had been filed, and then it took another 5 years before it was registered. So that's a long delay between launching a product on the market and getting protection for the trademark. Obviously it's a neat trademark and it's a valuable business asset, but it's a long time to be in the marketplace with little if any protection. So when you coin a new trademark, it's a good thing to have input from the trademark people as well as the marketing people, because what the marketing people think is a good idea might turn out to be a bad idea from the point of view of trademark protection. Of course, there's always the law of passing off to fall back on, but the whole point about registered trademarks is that they're much cheaper to enforce than an unregistered trademark that you have to sue for passing off over. And in any case, the whole basis of the passing off action is that there's enough goodwill in the trademark, whatever it is, to merit protection. And if you've got a descriptive trademark, then you're going to have the same difficulties bringing a passing off action as you're facing in trying to get it registered. Section 3.1d says that trademarks which consist exclusively of signs or indications which have become customary in the current language or in the bona fide and established practices of the trade will not be registrable. Just looking at the wording of that, you'll see, I think quite easily, that this is something that is more likely to happen later in the life of a trademark than at the outset. And what we're talking about here as absolute grounds for refusal of registration are also grounds for invalidity. So that's when this genericide problem can raise its head. I'm only aware of one case where a trademark was refused registration on these grounds, or in fact on similar grounds, because it was back in the 1900s and the law was very different, but the same principle applied. and in that case the trademark was gramophone. And in the application they said that they wanted to register it for gramophones. So even before the ink was dry on their application form, genericide had been committed. Of course, it could be a problem with a new trademark as well. A company like Hoover, which feels a need to expand its trademark portfolio in some way, might find that it has problems. And if you've got a trademark like that, you've got to work very hard to try to ensure that it doesn't become customary in the current language or in trade practices. And that means taking steps to put people right when they misuse your trademark. So problems of lack of distinctiveness, descriptiveness and genericness, if that's the right word, can all be solved by acquired distinctiveness. It doesn't help with the first of the absolute grounds for refusal, which is that your trademark isn't a trademark. Any amount of use of it isn't going to change that. But the other three grounds in paragraphs B, C and D of section 3 subsection 1 can be cured if before the date of the application for registration, so that's important, you can't fix things after you've put the application in, you've got to choose the time for the application quite carefully. If before that date it has in fact acquired a distinctive character as a result of use made of it. So that would be how the Windows trademark eventually found its way onto the register, and a lot of other trademarks too. You don't usually have to show a great deal of use for the trademarks registry to be convinced. I've found that a couple of years is generally enough, but it does depend on just how deficient the trademark is and how hard you've got to work to convince the public or to educate the public to recognise it as a trademark instead of just an ordinary word or name. Here's another celebrated trademark case where one of a number of issues was acquired distinctiveness. No problem with registering the Kit Kat trademark, but not so easy to register the shape of the chocolate bar, or I should say the chocolate wafer bar, because to my mind the big drawback of Kit Kat has always been that it's not all chocolate. Has this shape acquired any distinctiveness? Well, no, the judge said, because this isn't on display at the point of sale, it's wrapped up, so it can't do a trademark job. It can't attract customers. Shapes of goods and their packaging became registrable for the first time as trademarks in 1994. That was a major departure in the legislation, because up till then even such a well-known shape as the Coca-Cola bottle had been refused registration as a trademark. But the government certainly didn't want trademark owners finding a way of carving out some new protection for functional designs. Don't forget that the Copyright Designs and Patents Act 1988 was still pretty new, and they'd put a great deal of effort into trying to make sure that they'd devised a rational system for protecting functional designs, so they didn't want the trademark system upsetting that. So you can't register the shape of goods or their packaging, or now, as a result of the 2019 amendments, other characteristics of the goods or packaging, which result from the nature of the goods themselves, or if the shape is necessary to obtain a technical result, or if the shape gives substantial value to the goods. And when I say shape, I mean shape or other characteristics. The Philly Shave electric shaver is there as an illustration, because that was the subject matter of probably the most important case in this field, where Philips, the manufacturer, claimed that the layout of the three cutting heads on the top of the device was distinctive and should be registered as a trademark. But the truth is that that was a secondary matter, that in fact the design was there to achieve a technical result, and in any case the judge wasn't convinced that it was doing a trademark job. There are exclusions for public policy and morality, as you find in all areas of intellectual property law one way or another. So a trademark can't be registered if it's deceptive. So it might be designed to deceive you about the origin of the goods, for example, to make them look more British than they really are when they're made in some sweatshop on the other side of the world. Or indeed, a few years ago, an electronics retailer in the UK started using a Japanese name for its own brand products, which I don't think ever ran into this deceptiveness as a trademark problem, but it strikes me as an illustration of the sort of thing that can be an issue. If a trademark's applied for in bad faith, it'll be refused. Very difficult to prove, but If the trademark has been devised by somebody else and they've acquired something of a reputation in it, then another party's application to register it, in the knowledge that it really, in inverted commas, belongs to somebody else, that would be resolved by applying the bad faith rule. Under this heading as well, I'm also including specially protected emblems, national flags, emblems of international organisations, Red Cross, the Olympic rings, which have got strong protection under their own legislation, in fact. Lots of things which the law says you simply can't use these as trademarks. Anything which suggests a connection with the royal family, even if the organisation involved has got royal at the beginning of its name and operates under a royal charter, they've still got to get permission before they can register a trademark. These things fall under the heading that I've lazily put in there of other exclusions from registration. But since I've gone past 40 minutes, I'm sure you'll excuse me if I bring this presentation to a close. Thanks very much for listening. If you found this useful, do please subscribe to my channel, and you'll get to hear about further productions when I put them up there. It also gives me a bit of encouragement. If you want to learn about the subject in more detail, then watch out for information about where you can find longer and more detailed and specialised lectures. And please give me a like, leave your comments, because that's encouraging. I enjoyed having you as an audience, and I'll be back soon with more about trademarks, and indeed more about other areas of intellectual property as well. Bye for now.